Welcome to Team Tigio Court TV, where we upload videos every single day. So make sure you subscribe to our channel, like our videos, and share our videos.
All right, we have one case that's on our docket for today, and this is a mock trial, so everybody understands that we're going to take some liberties with the procedures that we would usually use in court, starting with the selection of the jury. Normally, you have to be of good moral character to serve on a jury. We're going to dispense with that rule so that we can let the five of you, serve, and we won't have to worry about whether or not you qualify. Is that all right with y'all? And then the next step after jury selection, well, actually during jury selection, both sides would have an opportunity to ask you questions, and then they could exercise what are called preemptory challenges. So either side wish to question the jurors, prospective jurors? All right, then we'll allow you all to serve. So that will expedite things quite a bit. The next step would be for the reading of, or for me to give you the, they would be sworn in, and then I would give you an initial set of instructions. Those instructions are usually 15 to 16 pages long. We will not read you the 16-page instructions, but we'll try to give you a little brief overview of what that's like. We will ask you to stand and be mock sworn in, so as the jurors.
Do each of you solemnly swear or affirm that you will try, well, and truly try the issues of the state of Tennessee is the plaintiff, and Hal Bush is the defendant, and a true verdict give according to the law and evidence, so help you God.
All right, thank you. You may sit down. All right. Now, it's my understanding we don't have an actual indictment, is that correct? But we understand that the defendant is charged with domestic violence. Is that my understanding, General Crouch? All right, and I want to give you a little bit of instructions about this case. The state is represented by the District Attorney General for the 23rd Judicial District, Mr. Ray Crouch, Jr., who's here, and seated with him is his witness, and I'll let him introduce who that might be. So. Then we also have the defense, Mr. Bush, who is represented by Shelby Sylvie, an attorney of good standing. So at this point in time, the next step would be for me to read you a set of instructions. Those instructions are general outlines of what you as jurors would be doing and what the charge would be. And it would be basically that you would be advised that he is charged with domestic assault and that he is presumed to be innocent until such time if ever the state proves his guilt beyond a reasonable doubt. It also, the instructions would be to give you some instructions on what you as jurors would be doing and what the trial judge and the lawyers would be doing during the trial. I would give you a set of instructions regarding the law as well. And some of those instructions would be the definition of the offense of domestic assault, which is a domestic assault is basically an assault that occurs in a domestic situation. And then the second thing would be that you would be advised that the state has the burden of proof beyond a reasonable doubt. And for you to find him guilty, the state would have to prove beyond a reasonable doubt that he committed an assault against a person with whom he was in a domestic situation. The reasonable doubt standard is not beyond all doubt, but rather is to a moral certainty, and that's the law that would be instructed to you to do that. You would also be given a set of instructions regarding how you are to weigh the credibility of witnesses, and we'll dispense with that because I trust your judgment. You'll be listening to these people and probably won't believe any of them, but you can go ahead and make your own decision. So, all right, so the state has the burden of proof, and they will then read, the next step would be for the reading of the indictment against the defendant. General Crouch, do you wish to read the indictment? All right, so the indictment would be read, which is charging him with on a certain day with committing the offense of domestic assault. To that indictment, how does the defendant plead, Mr. Bush? All right, not guilty. And whenever you need to, you can turn on your microphone. We've been through this on every criminal docket call day, as you know, so, all right. So the next step would be for the state to put on, make an opening statement. Does the state wish to make an opening statement? Waived opening, does the defense wish to make an opening statement? Right. Both sides have waived the opening statements, so we'll move now to the state's proof. State may call your first witness. Come up, please.
Charlotte Richards,
Thank you. And spell your last name, please.
Richards.
Court reporter has to make sure she identifies you properly.
Grab the base of that microphone and pull it towards you, please. There you go.
Okay, Ms. Richards, can you tell the ladies and gentlemen of the jury why you're here today?
I was assaulted by my boyfriend,
Who is your boyfriend?
Kyle Bush.
Are you still together with the defendant?
No,
Now, do you see Kyle Bush in the courtroom today?
I do.
And can you identify him for us, please?
He's sitting right there.
And what's he wearing?
Black and gray polo.
Okay. How long were you dating Mr. Bush before this incident?
Oh, 2 years.
2 years? And go back to the night when you were, I believe, at a restaurant, is that correct?
A bar, a restaurant.
A bar? Which bar were you at?
Dixon Sports Bar.
Dixon Sports Bar? Who were you there with?
Kyle Bush.
Anybody else?
No, just the two of us.
Just you two?
Just the two of us went there.
Okay. Did you all ride together?
We did.
Whose vehicle?
Mine. No, his. No, mine. I'm sorry. Mine.
Your vehicle?
Yes.
All right. Is it a truck or a passenger sedan?
It's a sedan, passenger sedan.
Okay. Who drove to the bar?
I did.
And were you drinking?
No.
Did you drink while you were at the bar?
No.
Did Mr. Bush?
Yes.
What did you observe him to drink?
Beer.
Is that what he usually drinks?
Yes.
Okay. What happened while you were at the restaurant with Mr. Bush?
Someone would look at me and he would get jealous thinking that we were talking or I was cheating on him, and he just started being really belligerent, getting angry and angrier the more he drank, and I felt like it was a good idea to leave.
Okay. Did you make contact with any other folks while you were at the bar? I mean, did you speak to another man, or did another man approach you?
No, sir.
But you observed that he was getting angry?
Yes.
How so?
He would grab my arm like nonchalantly and just say like, I know you're talking to somebody, or I know you're cheating on me. And I would tell him repeatedly that I'm not, but he would just get angrier and angrier throughout the night.
Okay. How long were you at the bar?
I can't recall, honestly. I don't want to give a false statement. I don't know how long we were there.
Okay. Well, let's give it some context. If it opened at 5 p.m. and closed at 2 a.m., were you there the entire time or for a shorter period of time?
A shorter period of time, maybe a couple hours.
A couple hours. All right. And what prompted you to leave?
One, I felt like he was kind of making a scene. He thought he might have been being discreet, but I could sense that people were starting to kind of stare. And I just felt like it was better to get out of there.
Okay. How did you leave?
We drove home. I drove.
Well, I'm asking more specifically, if you noticed people may have been paying attention or thought that he might be causing a scene, did you tell him, hey, it's time to go, or did you nudge him to leave, or did you get the bill and pay and leave? How did it go down?
I just grabbed the keys and I just kind of headed for the door, and he followed.
Okay. What happened when you got to your car?
I kept saying really rude things, just being belligerent. I just continued to get in the driver's seat, and he got eventually in the car, and we took off
Where were you driving?
to our house,
And where is that house?
144 Deed Street.
Is that in Dixon County, Tennessee?
Yes.
All of these incidents occurred in Dixon County, Tennessee?
Yes.
All right. As you were driving to your house, what happened?
He pulled my hair. He punched me in the side of the face. He grabbed my arm. Again, just saying some really terrible things.
Can you describe for the jury how he was pulling your hair?
He would grab the back of my head and kind of just pull my hair, and just grab my arm aggressively as he was talking. And at one point, he just kind of struck me in the side of my face.
And this is while you were driving?
Yes.
Did it interfere with your ability to drive the car?
Yes.
Were you able to make it home without wrecking?
Yes.
Okay. Tell us about your hair. Did anything happen with it?
When he pulled my hair, I do believe some of my hair came out.
In the car?
Yes,
And did you observe your hair lying in the car?
I did.
Okay. What happened when you got home?
I was terrified. I didn't want to make a report or call the police because I didn't know what he was much more capable of doing. So I went in our room and I just went to bed.
You went into your room? You went to bed?
Yes.
What did he do?
He continued to drink, but he stayed out in the living room, and that was the end of that.
If you were in bed, how do you know he continued to drink?
I could hear him playing loud music, going to the fridge. I could hear another can open or being opened, which to me just means that he was staying up and he continuing to drink.
Did he drink canned beer?
Mhm.
Did he drink canned any other drinks? Meaning, if you didn't see him, how could you distinguish the of a can opening?
Gotcha. We didn't have any soda in the fridge.
Okay. So if you heard a can opening, it had to be beer.
Yeah.
All right. How late do you think he stayed up drinking?
I can't recall.
What'd you do the next morning?
The next morning, I waited till he got up and went to work. I packed as much things as I could, and I left to go to a friend's house to get away from there.
Anything else happened that day of significance?
Yes, I decided to go to the sheriff's office to make a report because I felt like I needed to make a report.
And did you communicate with the defendant at all that morning?
No,
No text messages?
not that morning. It was when I was on my way to the sheriff's office that he began texting me.
Okay. So did he know you were on the way to the sheriff's office?
I did not tell him, and I turned my location, we use Life 360. I turned it off. I don't know how, at first I didn't know how he was able to find out where I was going.
Okay. Approach the witness, Your Honor.
You may.
Ms. Richards, you said that you had received a text message from him. Is that correct?
That is correct.
And you submitted your telephone to the Dixon County Sheriff's Office for a forensic extraction.
I did.
And do these records reflect what the text messages that were sent between you and the defendant
Yes.
as you were going towards the sheriff's department?
Yes.
And what is this first text message?
In all capital letters, it says answer the phone.
And next?
I know you turned Life 360 off.
All right, next.
I replied, I'm not doing this with you. That's the last time you put your hands on me.
So there were two messages, answer the phone, and I know you turned Life 360 off, is that correct?
Yes.
And those were from the defendant?
Yes,
And your reply was, I'm not doing this with you, that's the last time you put your hands on me?
that's correct.
What's the next message?
It's a picture. He sent a picture of his firearm. He's
Okay.
got a Glock.
And do you have that picture with you?
I do.
Can you hold it up for the jury to see? And can you describe that firearm?
It's a black Glock.
Okay, is there something attached to the Glock?
It's got a light.
Okay, so had you seen this pistol in person?
Yes,
You've seen it in his hand or him carrying the pistol?
yes,
And he sent you a picture of the pistol in this text thread?
Yes.
All right. And what's the next text message say?
He says, "You talk and I have something for you."
Okay. And next?
I say, "Leave me alone. Don't contact me anymore. I'm going to the police."
When you saw the text message from him immediately following the photograph of the pistol, what did you think?
I was terrified. I mean, I feel like he was threatening to use it on me if I spoke to the police.
And Your Honor, I would make this collective Exhibit 1, please.
Any objection? Mark it Exhibit 1 collective, so.
Ms. Richards, when you got to the Dixon County Sheriff's Office, did you go to the administrative building?
I did.
What happened there?
As I was parking, I had parked and I was getting out of my car. I saw his truck drive by, so I started to walk faster towards the building, and then I heard shots. It's a picture of my parked vehicle. You can see me running towards the entrance and then his truck driving by.
Will you show that to the jury? So what color is his truck?
White.
And can you point to it on the picture? And then point to yourself. And what are you doing there?
Running.
Why are you running?
Because I'm scared. I heard gunshots.
How many gunshots did you hear?
More than one. It was a couple.
At least 2?
Yes.
Maybe 3?
Possibly, yes.
All right. I'll make that State's Exhibit number 2, please.
Mark it as Exhibit 2.
And can you identify this photograph?
Same parking lot. You can see my car is parked and you can see his truck and going in the opposite direction as if he turned around and now he's leaving.
Notice in that photograph, it's different from the previous because the truck is going in an opposite direction.
Yes.
In this photograph that you have in your hand, is the driver's side window and door closer to you?
Yes.
Is the window down?
Yes.
And can you identify who's driving the vehicle?
Yes.
Who is driving it?
Kyle Bush.
Defendant?
Yes.
Is there anybody else in the vehicle?
Not that I can see, no.
Make that State's Exhibit number 3.
General Crouch, are you asking that these photographs be exhibited to the jury, passed to the jury?
Yes.
All right. Ladies and gentlemen, sometimes in a trial, we will have exhibits like this that can be demonstrated up on the big screen. With this being a mock trial, we're not going to that extent, but you do get to look at the photographs closely.
Now, Ms. Richards, I would ask you to turn your attention to the screen. I think you've already identified the car on the far left side, is that correct?
Yes,
That's your vehicle?
that's
And
correct.
that's when you parked at the Sheriff's Administrative Building?
Yes.
One more time, Ms. Richards, will you describe for the jury what just happened on the screen? Because I'm not sure that all of them were paying attention.
I got out of my vehicle, and as I was exiting my vehicle, I saw his vehicle approaching. I heard gunfire, and I started running towards the entrance. He turned around, and I could see that it was him driving, and he sped off.
Okay. You get out, you see his truck, you hear gunfire,
I do.
and you see him driving.
Yes.
Your Honor, I will make a copy of this video the State's next exhibit. It'll have to be late filed, if ever filed, because I don't have a
All
disc.
right, we'll
of it.
mark it as late filed exhibit.
Thank you.
Next in order, number 4. Libby, are they being graded on how well they pay attention?
Oh, they're looking at the
Apparently, high school students' attention span is just about what it was when I was in high school, so.
Okay, so Miss Richard, we're almost finished. I have a couple more photographs.
That would be a fingernail.
Whose fingernail?
That is mine.
How do you know it's yours?
Because I remember getting my nails done and it looking exactly like that.
Okay. Why is your fingernail laying in the center console of your car?
Because while we were driving home from the bar, I would put my hand up to shield him from grabbing my arm or hitting me in the face. Just the struggle alone, I guess my fingernail came off.
Okay. So kind of big picture, your hair was pulled out of your head and was found in the car, and your fingernail was ripped off of your finger.
Yes.
I'll move that photograph as the state's next exhibit, please. Can you describe first, were you scared during this incident? Both incidents, the one at leaving the bar, going to your house, and then the one at the sheriff's department.
Yes, I was very scared.
What, on a scale of 1 to 10, 10 being the most scared you've ever been in your life, what were you?
10.
10. Why?
Because there was a gun involved. Like I felt like he was going to kill me.
And you heard shots fired.
Yes.
You think those shots were fired at you?
Yes.
I'll pass the witness.
I don't guess I can call you General Sylvie. Actually, she is the domestic abuse prosecutor for the 23rd Judicial District. But before that, she used to be a public defender in Montgomery County and to the north, whatever that county is up there. And so we flipped her around, and she's now a prosecutor for the domestic abuse cases that we have in our district. But now, tonight, she's reverting back to her role as a public defender, defending someone charged with us, so.
All right. Miss Richards, how are you?
I'm fine.
Okay. Now, I want to ask you a couple questions, and I'm going to go kind of chronologically like the state did, okay? So I want to start with the bar, okay? So I want you to think back to what you were telling us about being at the bar. That was the night before, correct?
Yes.
All right. And you said that you drove there and back. All right. And your testimony is that you were sober this entire time.
Yes.
So you also testified that he was angry when inside the bar.
Yes.
So if you drove there or back, I assume you had a purse on you
Yes.
and you had the keys to your car in your purse?
Yes.
So if he was angry and belligerent, why not just leave
I did leave.
without him?
No, I grabbed my keys and walked towards the door and he followed.
Okay, and I do remember that testimony. So you get out to your car. So you didn't ask him to come with you. You didn't tell him it was time to leave or anything like that.
I did say, hey, it's time to go. It's time to leave.
Okay, so you intended for him to go home with you.
I knew he was making a scene and drawing attention to us, and I wanted to de-escalate the situation, so I said, we should leave.
Okay, so you weren't scared of him at that time?
All I said was, we should leave.
My question.
Yes, I was scared.
You were scared, but you invited him to come home with you.
I would say anything to get out of that bar.
Okay, and as you went outside, you stood out in front of your car, correct?
That is correct.
And you said he was angry and belligerent and saying rude things to you. And at that time, you'd not gotten into your car yet.
I was heading towards the door to get into the car, yes.
And you still let him get in the car with you.
I was not going to fight him.
And you were in a public place.
That is correct.
And he got in the car with you.
Yes.
Why leave the public place?
I was terrified. My reaction was just to get out of there. I might not have been thinking completely rationally. I was just trying to get out of there.
So you're terrified of him, and your response is to drive off with him in the car, you two alone. That's your response
It's to go home, yes.
with him,
If that's what happened, then that's what happened.
where you're going to be alone. And you're terrified through this entire time frame.
I am.
Did you have a cell phone?
I did.
And so where was your cell phone during this entire time?
In my purse.
He never took it from you. You had it in your purse.
It was in my purse.
Why not call?
I should have.
When you were in your bedroom and he was in the living room, anything keep you from calling then?
I was scared that things would get worse if I called. I didn't know how much angrier he would be if I called. So I was just too afraid to call.
When he got up and went to work, why not call?
Because I made the decision to pack my stuff and to leave, and I was going to go make a report. But I wanted to wait till he was gone.
Now, I want to go back to Exhibit 1, and I don't know if I'm going to have the court clerk pass you Exhibit 1. All right. So we went through these texts earlier. It says Kyle at the top, but his number's not shown. How do we know that's actually Kyle that's using that text right there?
Yes, if they did a forensic dump on the phone, then that would provide a number. But just from the first glance, I can see why you don't see the number, but
And then we go through the series of texts. It says, answer your phone. Who was your testimony that that was from?
Kyle Bush.
And then it says, I know you turned your Life 360 off. Who is your testimony that that text is from?
Kyle.
And then there's a text that says, I'm not doing this with you. That's the last time you put your hands on me. Who is it your testimony that that text is from?
From me to him.
Why is it not on the other side of the sheet?
I don't know.
Do you usually get text and incoming and outgoing text are on opposite sheets, opposite sides of the screen?
I guess.
But this one is in the same exact series.
I can't control how that looks on my phone.
All right.
That would be a technical problem.
So every other time that you get a text, the response text is on the opposite side of the screen, but this day you had a technical problem and the response came in on the
I'm
same
not saying
side of the
that
screen.
I had a technical problem. I'm just saying that that's what was seen on my phone.
Okay. You didn't text that to yourself?
No.
Who's your testimony that says you talk and I have something for you?
That message came from Kyle.
Okay. And then the leave me alone, don't contact me anymore, I'm going to the police. Who is that text from?
That is from me.
And again, it did not swap to the other side of the screen? No? And this isn't a group text or anything like that, it's just between you and Kyle?
That's correct.
And every other text you get with one other individual, the bubbles go back and forth on either side of the screen, but it didn't do it in this time. Okay. So let's go to Exhibit 2. Could you pass Exhibit 2? All right, so this is the parking lot you said that you were at?
Yes, ma'am.
All right. Now, when did you see the white vehicle pull up? Was it while you were parking or?
I was already getting out of my car, closing the door, and I
Okay.
saw it.
And you saw him driving, how far away from him, from your vehicle was he? When you first noticed the white vehicle?
Like 2 car lengths away,
How did you know it was his vehicle?
because I recognize his vehicle. I know his vehicle.
Why?
And I saw him in the driver's seat.
How did you see him, through the front windshield?
No, I saw him as he was taking off through
Okay.
the passenger side window, or the driver's side window.
Okay, so that was actually when he came back. So you didn't see him until he was coming back after?
No, I saw him approach
Okay,
and then pull into a small parking lot and then go in the opposite direction to leave.
okay. So when did you actually know that he was the person in the vehicle?
As he was approaching, but I
Okay.
could get confirmation for sure that it was him as he was leaving. But I recognized his vehicle.
Okay. So in this photograph in Exhibit 2, is the passenger window up or down?
It's up.
And when you were talking about the gunfire, you said you heard the gunfire.
Yes.
Where were you at when you heard the gunfire?
And you were just back of my vehicle running towards the entrance of the building.
So did you actually see anything or did you only hear it?
I only heard the gunshots.
Okay. Now, let's see. When you're running in this picture, the gunfire had already happened beforehand, correct?
From the time I exited my car and ran to the building, between that time is when the couple shots were heard.
So they were heard, but this passenger window is up, and you did not see anybody fire a weapon.
I did not.
And you would agree that you only noticed him when he came back and the driver's side was towards you, correct?
When I got out of my vehicle and I saw the truck approaching, I could see from the front of the vehicle through the window of who the driver was. And then I saw him again as he was leaving with the driver's side window down.
Okay. Was there anybody else in the vehicle?
Not that I could see.
Right now. Now, what time? No, so I'm not gonna ask that one. Know that the state asked you if you were scared on a scale of 1 to 10, and you said you were scared to a 10.
Yes.
Then you talked about the gunfire and things like that. At what point in all of this, because we've talked about 2 different incidences. We've talked about the night before, and then we've talked about this day at the police. Can you specify when you were scared to a level of 10?
The incident, or the day that I went to make a report.
Okay. Because we've already gone through the night before you didn't leave without him at the bar, you went with him. When you got in the car, you drove to a secluded place to your home. You also had a cell phone on you all of those times, correct?
That is
And did-
correct.
And didn't call? And then, so when you say you were scared to a level of 10, you're specifically talking about the day that at the police station. when you
I
went
was
to go
scared
make-
on both incidents, but not as scared as I was on the second incident.
I have no other questions, Your Honor.
Redirect, General Cross.
Just to be clear, the text messages from the defendant to you,
That is correct.
And that was as you were driving to the administrative office?
Yes.
You talk and what? What did he say? If you talk, what did he tell you?
I've got something for you.
And what picture did he send?
Picture of his gun.
This exhibit?
Yes.
So you talk and I have something for you?
Yes.
Okay. So
You brought the wrong Etheridge.
it's his computer. He's here in spirit. This has been a previously marked exhibit. I want to ask a couple of questions, following up to Ms. Sylvie's questions. That's you?
That is me.
At this point, have you heard any gunfire?
No.
When do you see the defendant's truck?
And then next second or two.
Are you looking at his truck right now?
Yes.
You can see him coming up the road?
Yes.
How many gunshots?
Can you replay it? I'm sorry. Four.
You heard 4 gunshots?
Yes.
I don't want to put words in your mouth, but were you or were you not looking towards his vehicle at least twice when we heard gunshots?
I was.
Did those gunshots come from that truck?
Yes. They came from that direction. Yes.
Who was driving the truck?
Kyle Bush.
No doubt in your mind?
No doubt.
I'll pass the witness.
Recross.
When you got out of the vehicle, why did you have your hands to the side of your head?
I had my phone in my hand.
So you do have a phone. Who were you talking to?
I was talking to dispatch.
You never said that you called dispatch.
I was on the phone with dispatch because I went to the sheriff's office to make a report. That's why I was there.
When did you call police? Because in none of your prior testimony, you said anything about calling police.
I wasn't asked
When did you call police?
as I was en route to the sheriff's office.
But you never used that phone until then to call for help?
No.
Okay. And you said you still only heard the shots. You never saw any shots fired.
That's correct.
You can only say what direction they came from.
They were coming from that direction, the truck, yes.
Is that what highway's back there?
That's County Jail Drive.
Pretty busy highway?
If you're going to the jail or the sheriff's office, that's where that road leads to.
And then this is at the police station or headquarters? What is the name? Administrative building?
Yes.
Officers there? Were there officers there?
There was a deputy there.
Okay. Do officers carry guns?
Yes.
I have no other questions.
Anything further? Turn the lights off. Thank you, ma'am. You may step down and have a seat.
Do you solemnly swear affirm the testimony you give in this
Detective, will you state your full name, please,
Rachel Ruiz,
and spell your last name?
Ruiz.
Thank you. And Detective Ruiz, how long have you been employed with the Dixon County Sheriff's Office?
10 years.
10 years? All right, thank you. I knew you looked familiar.
Awfully young for your age. Most 10-year veterans of the police department look a lot older. So.
Detective Ruiz, were you assigned to investigate the case involving the defendant, Mr. Kyle Bush?
I was
What was your role in the investigation?
lead detective.
Lead detective. Okay, very good. In the course of your investigation, did you collect and receive evidence that was collected outside of the sheriff's administrative building?
Yes.
All right. Detective Ruiz, please.
It's a evidence and property receipt release form.
Okay. Let's go through some of the evidence that was collected in this case. Can you identify the item number and then the description of the property?
It was item number one. Well, 1, 2, 3, and 4 were all 9mm shell casings.
Okay.
There was item number 5 was the clump of hair located in the front passenger seat. Item number 6 was another clump of hair located in the back passenger seat. Item number 7 was another clump of hair located in the back passenger seat floorboard or back passenger floorboard. Item number 8 was one air tag. It was behind the driver's side in the wheel well. And item number 9 was one acrylic fingernail.
Thank you. So Detective, 4 9mm shell casings were collected outside of this building here?
Correct.
On the roadway?
Correct.
And those were turned over to the TBI lab for testing?
Yes, sir.
All right. And then it looks like 3 separate samples of hair were collected from the victim's car?
Correct.
And can you describe, and you may not know off the top of your head, the locations of the hair?
Inside the car, in the front passenger seat, back passenger seat, and the floorboard.
Thank you. And there was also an air tag collected, is that correct?
Correct.
Did you collect that?
I did.
And did you do any type of investigation on the air tag itself?
Um,
I believe there was a search warrant that was applied for.
yes, sir.
And I'm not sure if you did that or not.
And I didn't know.
Okay. We'll get back to that later. And then there was also an acrylic fingernail collected.
Yes,
That was submitted to the TBI lab.
I believe so, yes.
I'll make the evidence property report the state's next exhibit, please.
No objections, Your Honor.
All right, mark as Exhibit 6.
Detective, can you identify this photograph, please?
It's one of the shell casings.
All right. And I think you've already testified that that was sent off for testing.
It was.
And there was a total, I'm not going to move 3 separate or 4 separate photographs, but does that is one of the shell casings that you collected?
One of the 4. Mhm.
I'll move that as the state's next exhibit, please.
7.
Detective, I'm going to hand you a series of 3 photographs, and it appears that they have evidence markers number 5, 6, and 7.
Okay.
If you would please identify these 3 photographs.
Items 5, 6, and 7 are all hair found inside the car.
That's the hair that was collected from the car, and the car was parked in front of the administrative building.
Yes.
All right, I'll move that as the state's next collective exhibit, please.
8.
Please identify this photograph.
The AirTag.
Do you remember where on the car the AirTag was found?
The driver's side wheel well.
So not inside the passenger compartment, but outside underneath the wheel well.
Correct.
Is it magnetic?
It was stuck. It was stuck there with like double-sided sticky tape.
Okay. So have you seen an AirTag before? Like, are you familiar with AirTags?
I'm not.
Okay. So you don't know whether they come with double-sided sticky tape or somebody had to attach sticky tape to it.
Right. I don't know.
Okay. State will move that photograph as the next exhibit, please.
Exhibit 9.
Detective, did you collect, or were you there when the defendant was apprehended, arrested?
I was not. No.
Do you know which detective or road deputy was present for his arrest?
I believe the other detective was.
And do you know the other detective's name?
I don't.
Okay. It's such a huge department. I know that you don't know all of the other employees.
A huge department.
Yeah. There's hundreds of detectives. She doesn't know all of them. So Detective Ruiz, what else did you do as far as the investigation in this case?
I was just there collecting evidence.
Okay. I will pass the witness.
Sylvan, do you have any questions?
Detective Ruiz, you found 4 shell casings, correct?
Correct.
All right. And while we have, I believe this is Exhibit 4. Still up on the screen. We have Exhibit 4 still up on the screen. During the state's questioning, you said you collected the evidence.
I did.
Did you collect these 4 shell casings?
I did.
All right. And which part of the parking lot did you collect those casings?
More around towards the black truck.
This black truck.
On the right, yes.
All right. And have you had a chance to watch this security footage?
I have, yes.
Did you ever see that white truck enter that parking lot?
No.
Okay. So you collected shell casings, 4 shell casings, from an area of the parking lot that the white truck never entered.
I never saw it enter, no.
Okay. Are you very knowledgeable about guns? You're a detective.
I say so.
Okay. So when you shoot a gun, what happens to the casing?
The casing falls on the ground.
All right. So it's ejected from the gun?
Correct.
All right. And we will agree that over there where the truck is not where we heard gunfire.
In front of the truck on the road.
So it was actually kind of off screen when we started hearing firing, correct?
Yes.
But you didn't find any shell casings over there?
No.
All right. And when that truck was entering, the assumption you want us to make is that the driver shot that gun?
Correct.
And it would have been on what's kind of the shadowy, dark side of that road, is that correct?
Yes.
But you found no casings over there?
No.
The 4 casings you found were in this parking lot over by this black truck?
Yes.
Let's talk about the hair you collected. Has her collected Exhibit 8. Oh, goody.
Let me interrupt you and just say, one thing I failed to, would have been in the initial instructions, if you were an actual jury, would have been to tell you that you had the right, as jurors, to ask questions yourself. And if you want to ask a question, you have to submit it in writing while the witness is on the stand, and then I'll consider it, and if it's legally admissible, I will allow it to be asked. But, so while you're sitting here listening, and you can consider whether or not you would want to ask any particular question of the witness, and if you do, you simply write the question down, give it to the bailiff, and then he'll hand it to me. Thank you.
So you're looking at Collective Exhibit 8. Now, in this exhibit, what time of day were these pictures taken of this hair?
It was at night.
Okay. But we can agree that she was at the station during the day.
Yes.
And this hair, is it in chunks or strands? How would you describe it?
In chunks.
Okay. Is that usually how hair comes out, is in chunks, or does it come out in strands?
I guess it depends on how it comes out.
And these pictures were taken at night.
Correct.
Were they taken the same day?
Yes.
What's the reason for the delay? Why wait and take it at night?
I believe that she was giving her testimony and it took a while.
Did you secure the car?
We did, yes.
How?
Nobody was to enter the car and she wasn't supposed to go to her car.
And how did you do that?
The defendant or the witness was, while she was giving her testimony, the detective that was taking her testimony just was aware that her car was there, so
Just aware?
yes.
Okay. I have no other questions, Your Honor.
Any redirect?
Detective, just to follow up on the shell casings, you're familiar with a Glock 19,
I am.
and if I were pointing a Glock 19 out of a window and fired 3 rounds, the shells would be ejected out of the window,
Yes,
and they would travel some distance,
they would.
thus placing the shells into the location where they were collected by you.
Yes.
Thank you.
Basis of your objection? Sustained? Any other questions? Any other redirect? Thank you, ma'am. You may step down. Resume your duties as a detective. Oh, wait, I'm sorry. Have a seat. We actually have one of our law class students has a question. All right, who wrote the multiple page questions? All right. Normally, what would happen when a juror submits a question, I'm by law required to send the jury out of the room, and then I ask the question, or I state what the question is to the lawyers, and then we have a discussion on whether or not that is admissible. My job is to rule on the admissibility of evidence, and that includes the questions that the jurors ask. So I would have to then look at the question. I'm going to take the single question first, and then I'll get to the multiple question. The question that, and I'm going to leave you in here so you can hear it. If the witness were punched before going to the station, would there not be a bruise or of some kind? If there was, is there a record for evidence? That's a good question. So I would suggest that to the lawyers, and then I would allow one of them to ask the question if they wanted, or I would ask the question. But since we're in a mock trial situation, I'm going to ask the question. You're not going to know the answer, but I'm going to ask you the question. If the victim in this case, Ms. Richards, I think was her name, if she was hit or punched before going to the station, would there not be a bruise of some kind, or on your experience, would there automatically be a bruise on an individual if they were punched a short time before?
Can I speculate?
You can.
Okay. Whenever the witness was giving her testimony, she was already shaken up, and I could tell that she was in distress, and so she was crying, and her hair was all messed up, and so there could have been a bruise.
Okay, and so for your education, detective, when you're talking about the victim coming to the station, she is giving a statement rather than her testimony. Testimony is only in court.
Okay.
That's all right. That's what, the whole purpose of this is for everyone to learn, including the lawyers. So the fact that you said it as testimony, it's actually a statement she was giving to law enforcement, correct?
Okay, yes.
All right. So there could have been a bruise, but you wouldn't have noticed it because of her state of upset.
Yes, sir.
All right. Now, we'll get to the multiple question page. All right, this question is, in the video, when the truck passes the second time, was there any tattoos on the driver's arm? And what I would tell you is, I would simply say, did you, they would be allowed to ask you that question, but if, the jury can look at the video the same as the witness, and they can interpret it the same as the person. So if you're looking at a video, then you can say whether or not you saw, did you look at the video?
I did, but we didn't zoom in, so, yeah.
So the second time around, did you see any tattoos on the driver?
As of right now, no.
Okay. So in a real world situation, the jury would be instructed that they make their own determinations of what the evidence is. This next question, does the victim wear glasses? Because in the video, the person wore glasses. Now, that's a good question. So it would probably be a question better asked of the victim when she testified, but that's a legitimate question. Do you know whether the victim wears glasses?
I don't.
Okay. I would say that it's the same person in the video, so she probably does wear glasses, just like me. She doesn't wear them all the time. So, can you clarify the shots was Glock shots? A Glock shot. Now that one is a little bit more difficult. Could you listen to the video and determine from the video what type of weapon was being used?
Mm-hmm.
And I'll ask you this question. 10 years of experience, and what's the standard weapon issued to the Dixon Police Department? It's a Glock, right? So
Yes, sir.
and it looks remarkably like the picture of what we've seen here. So when you fire a Glock, do you recognize when another Glock is being fired?
Yes.
So would you say that sounded like a Glock? Now, I'm actually questioning you as though I was the attorney asking you the question rather than the judge, but do you recognize that as being Glock shots?
I do, yes.
All right. And lastly, where would you estimate the shells should have landed? And I think General Crouch more or less speculated about how that would be, and General Sylvie objected to it, and in a real-world trial, I would have sustained that because it would be speculation as to where a gun in a truck passing by, a weapon is fired, and a witness is not likely, unless they have a degree in physics and can do an experiment, they would not likely be able to say where those shells are likely to show up. They could give you a possibility, but they couldn't give you a definitive answer. All right. Then any other questions for this? And we are ready to allow you to step down. Thank you. Oh. Now see, if I hadn't told you you could ask questions, we would have been further along. And trust me, there are trials when the lawyers regret the fact that I tell jurors they can ask questions too. So, okay. This question is, what color was the hair? I'm assuming that's the sample of the hair that you recovered. Do you know?
Brown.
Brown. Why was the hair not tested? Do you know the answer to that?
Because we had the, was it the witness? Or,
Miss Richards?
right, we had Miss Richards giving her statement, right, her statement, and her hair was brown, and so we didn't feel the need to test it because her hair was brown.
And testing evidence is not always required in a real-world trial. For example, what would be the purpose in testing the hair in this situation? Any of you want to speculate about that? Testing it for what, drugs, alcohol? To make sure it was hers. So you would like to have DNA testing of the hair, is that correct? It's likely that would not occur in a real trial because of the fact that you had a sample of hair that was taken from the victim, and the victim was there and says, that's my hair, it's unlikely that now the defense might, do that, but that would simply prove that the defendant in the case had pulled some other woman's hair out in another situation, so it might not be a good thing to do. All right. Anybody else have any questions then before? All right. Probably a good thing we only had 5 students, so. All right. Thank you, ma'am. You may sit down.
Thank you.
General Crouch, you may ask your next, call your next witness. Step right up, raise your right hand.
You solemnly swear or affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God.
Good evening. Will you state your full name for the court, please?
Jeremy Etheridge.
All right, and
Mr. Etheridge, pull that base of that to you so that we can make sure we can hear all about you. I didn't ask you to do that, but you
Let's
can.
make sure it's on.
All right.
Detective Etheridge, you are a laboratory agent with the Tennessee Bureau of Investigation.
Yes,
You reviewed several items in this case, is that correct?
yes,
And let's just back up a minute. When it comes to the testing of hair, the TBI does not perform hair testing, do they?
no,
There is no place that you know of in Dixon County or within the TBI that a piece of hair can be submitted to confirm whether it came from the victim or some other place.
that's correct.
When looking at hair sample, we look at the color and nature of the hair. It's more of an eye look, is that correct?
Yes,
All right. So let's talk a little bit about the weapon that was recovered from the defendant, a Glock Model 19. You received that weapon at the TBI,
yes,
and you also received the shell casings that were recovered from the crime scene.
yes,
Did you do a comparison between the shell casings and the Glock 19?
yes,
And I'm not going to get into how those comparisons are made, but it's scientific,
yes,
based upon years and years of the scientific method being applied.
yes,
And are you looking at strike marks on the shell casing?
yes,
Are those unique to each individual pistol?
yes,
So if I had a Glock 19 on my person tonight, which I don't, but I gave that to you, and then we took the Glock 19 that belonged to the defendant, you could distinguish. I haven't even asked my question. How's she objecting?
Let me hear the objection before you start in.
Your Honor, it's foundation. No one yet has even testified that a gun has been recovered from the defendant. We're now talking about TBI lab testing with a gun that no one's testified was ever recovered from the defendant. So we're getting into no foundation for any of this testimony.
That's fine, Your Honor. I can clear that up.
All right, sustain the objection at this time.
Detective, you received a weapon from the Dixon County Sheriff's Office.
yes.
How do you identify weapons as they come into the TBI lab?
Serial numbers.
Serial numbers. Are they signed off on by the agent or the detective that brings them to your laboratory?
Yes,
So while you may not be in the field, you are receiving a piece of property through a chain of custody.
yes,
We'll leave the defendant's name out of it, but you received a piece of property, a Glock 19, according to the property receipt. Is that correct?
that's correct.
And you examined a Glock 19.
Yes,
All right. You don't personally know where the Glock 19 came from, other than the identifying marks on the property receipt.
correct.
All right. Let's talk a little bit about the examination of weapons. Going back to my original questioning, if you have 2 Glock 19s, can you distinguish those Glock 19s?
Yes,
Do they make unique characteristic traits, strike marks on shell casings?
yes,
So you may have 2 Glock 19s that were produced in the same factory, one right after the other, but they would be distinguishable,
yes,
very unique,
yes,
so similar to fingerprints.
correct.
All right. And in this case, you did a comparison of the shell casings that you also received from the Dixon County Sheriff's Office.
Yes,
And you were able to do what?
I was able to tell that the 4 shell casings that were submitted come from the Glock 19 that was submitted as well.
Okay, and you were in the courtroom when the detective testified that she collected 4 shell casings at the Dixon County Sheriff's Office.
Yes,
She testified that they were turned in to you at the TBI lab.
yes,
You took those 4 shell casings and linked them to the Glock 19 that had been presented to you for examination?
Yes.
All right. Now, let's talk a little bit more about your work in this case. You produce a laboratory report every time you do an examination, is that correct?
That's correct. Yes.
And what is this?
It's a NIBIN report.
And is this an accurate copy of the report that you produced for this investigation?
Yes.
And let's just briefly go through it. It says evidence submitted by 1A sample cartridge DC SO1 sample caliber
Yes.
and casing 9mm.
Yes.
And 2C, what is 2C?
That's item number 2.
Right? And it's a Glock 19
Glock
firearm.
19. Yes, 9mm.
And what was the result?
The sample cartridge is a match with 2C firearm Glock 19 cartridge.
Okay. And are you sure of that result?
Yes.
And based on your result, the firearm that you examined is the firearm that fired the shell casings located at the crime scene?
Yes.
No doubt.
No doubt.
I'll move a copy of the lab report as the state's next exhibit.
All right, we'll make it I assume we're going to have some witness that will identify the weapon and.
We will.
So we'll provisionally, normally in a real trial, the weapon would have been introduced first. But sometimes those things happen and you can allow some piece of evidence to come in conditionally if it's later connected. So we'll allow it to be brought in subject to correlation to the weapon itself.
Judge, the witness is in real life on a call right now and was unable to be here temporarily.
The witness that we had lined up to testify about these things is on a DOA call at the moment with the Sheriff's Department, I assume. Anyway, that means a dead on arrival call. That means that that officer that was going to come in and testify is actually responding to a death call. So we'll overlook her absence.
Now, Investigator Etheridge, you serve many roles with the TBI. Not only are you a firearms expert, but you're also a seriology expert, is that correct?
Yes.
And you have a vast background in examining DNA.
Yes.
I'm tendering Detective Etheridge as a seriology expert. Any objection to that?
Just remember who you work for.
For practice purposes, I would
There's
not
no
object.
objections, right?
It's always interesting when we have these, the last one we had, General Crouch was the defense lawyer, and one of his assistants was the prosecutor, and there were times when you could see that the prosecuting attorney who works for him wanted to object, but kept her mouth shut because she didn't want to make her boss mad at her, I think. So anyway, we will allow this to be.
If she's watching, she's done much worse than that, so.
Oh, yeah.
Okay, so Agent Investigator Etheridge, we're now speaking of this seriology report that you have produced. What did you examine? Do you remember off the top of your head?
So let me interrupt you because I'm trying to make sure everybody, including our class of the Citizens Police Academy, in a real-world trial, in order to render an expert opinion, there has to be a qualification, and Mr. Crouch asked the defense lawyer if there was any objection to it. So normally you qualify someone as an expert through their training, experience, and so forth, and background, and they would be, the question would be asked if they could be qualified as an expert. I would make that determination, but we would give both sides an opportunity to question the background. So now that he's been qualified as an expert for this mock trial, he will be able to give an opinion, which is not something a layperson without being qualified as an expert would be able to do.
Okay, Agent Etheridge, we are now reviewing a document that you have before you. Can you identify this document, please?
It's an official CODIS report.
And that is also a laboratory examination?
Yes,
And is that your official, does that appear to be an accurate copy of your lab report?
yes.
All right. In this particular report, we have evidence that was received from who?
Charlotte Richards.
And which do you see underneath the victim, which is Charlotte Richards, where it says received from?
Yes, Rachel Ruiz.
And that's the detective we've heard testify.
Yes,
So Detective Ruiz brought evidence for seriology DNA testing, and they're marked as exhibits 1A and 1B, is that correct?
yes.
And 1A is what?
An acrylic fingernail,
Okay. And 1B is what?
victim's DNA swab.
All right. So a swab, what does that mean?
It's where they take, it's kind of like a long Q-tip, and they put it in the person's mouth and swab their cheeks.
Okay. So the victim, Miss Richards, somebody swabbed her mouth for DNA.
Yes,
And what do you do with that sample? Is that your kind of your comparison sample?
yes,
Is it a known sample from the victim?
yes,
All right. And so when you examine the acrylic fingernail, are you trying to determine if DNA on the fingernail matches the known sample, which is Miss Richards' DNA?
yes,
Okay. Did you do that comparison in this test, in
I
this
did.
case? You compared the DNA located on the fingernail to Miss Richards' known sample.
yes,
And was it a match?
it was.
Okay. So we know that the fingernail, that wherever it came from, because you weren't there, but if we've seen a photograph of it in Miss Richards' car in the a console, we know that that fingernail has her DNA on it.
Correct.
All right. And I'll make a copy of the CODIS and lab report, the state's next exhibit, please. Thank you. And then lastly, Agent Etheridge, we have Are you familiar with Apple AirTags?
Yes, I am.
You're very familiar with those as well.
Yes,
And I would tender Agent Etheridge as a forensic expert.
We will qualify him as an expert in that area.
Agent, can you describe to the jury what an AirTag is?
it's a more or less of a tracking device. They come with a serial number. You can put it somewhere and you can pair it to your iPhone and find out where it's at.
Okay. And an AirTag was examined by you,
Yes,
and in this particular case or in all cases, are AirTags in order to activate and be used, do they have to be associated and connected to an email address?
yes,
So when you go in and do an examination and subpoena the results from Apple, the proceeds from Apple, were you able to identify the email address associated with this AirTag?
yes.
And what is that email address?
KyleBush77@gmail.com.
Okay. So in this particular case, we have the serial number of the AirTag, and then we have the Apple ID that was used, and we see two separate emails. Is that correct?
That's correct.
We see one, KyleBush77@gmail.com, and do we have another?
crichard66@gmail.com.
Okay. And the status, can you go through the results of the status, please?
Yes, on 10/23/2025 at 2:58 p.m., it was, the device was unpaired from the Apple ID. On the same date at 4:30 p.m., it was attempting to pair up with the Apple ID event, or the Apple ID, and at 5:50 p.m., there was another attempt to pairing it up.
Okay. What does that mean
That
in layman's terms?
the person whose name it's under was attempting to turn it or activate it to see where the AirTag was at.
Okay. So whether or not it ever connected, you don't know,
I do not know.
but somebody was attempting to connect.
That's correct.
And an Apple AirTag, does it have a distance in which it will connect? Yeah, I mean, if I'm a mile away from the AirTag, and I'm trying to find the AirTag on my Apple phone, what is required for it to connect?
You have to be within close proximity of it.
Relatively close?
Yes.
Okay. All right. So on the same date that we've been speaking of this entire case, October 23rd, 2025, somebody was attempting to pair up with this Apple AirTag.
That's correct.
In your experience in examining AirTags, if the person that was trying to pair it was literally sitting in the car where the AirTag was, would that be close enough to connect?
Yes.
So if I'm in a car, I should be able to connect with an AirTag.
Yes.
But if I'm unable to connect, that means I'm somewhere outside or away from the car.
That's correct.
All right. I'll move that as the state's next exhibit, please.
Right.
And I'll pass the witness.
Sylvie, you may cross-examine.
All right. Mr. Etheridge, I'm going to start backwards a little bit. If you've got Exhibit 12, I'd like for you to peek at Exhibit 12. And that is the Apple Confidential Report, correct?
Yes.
We have some experience with Apple iTags, don't we?
A lot.
Yes. So let's go through can you tell me which user attempted to pair the Apple iTag?
No.
Or AirTag?
No, I
You-
cannot.
You can't tell me who
No.
did that. So it could have been Miss Richards with the Miss Richards email address that's up there.
Possibly.
All right. And all of this happened on what date?
October 23rd, 2025.
So that was actually the day before she came to the administrative building to make a report, correct?
I have no idea. I don't work for the sheriff's office.
Okay. And what have you done to verify that Kyle Bush actually uses the email address kylebush77?
I have not. This is just what came back from Apple.
All right, so you don't know who set up that email account?
Do not.
Anybody could have set up that email address?
Anybody could have.
Could I have set up that
Yes,
email
you could
address? Okay. So what we have here is something that says that an AirTag was attempted to be paired on October 23rd, but we don't know by whom?
That's correct.
Do you have any information of when that AirTag was placed on the vehicle?
I do not.
All right, let's move backwards again, and I'm through with Exhibit 12, and we'll go to Exhibit 11, which would be the official CODIS report. All right. You are an expert in serology.
Sure.
Okay. What does CODIS mean?
I don't know.
You don't know what CODIS
I
means?
don't. It's DNA something, with something to do with DNA. Or the results go in. So like if your DNA is taken, goes into the system.
It's CODIS usually classify certain individuals?
Yes.
What kind of individuals?
Humans.
Humans. Anything specific to humans?
I don't know.
Okay. All right. My next question would be, so your lab report verifies that Miss Charlotte Richards' DNA was found on this fingernail.
Yes.
Do you know where the fingernail was recovered from?
Don't have a clue.
Any other DNA at all that was submitted for you to test?
No.
Mr. Etheridge, if you could go look at Exhibit 10. This would be the NIBIN. Now, I heard a lot of testimony that you had regarding this. Is your name Mel Rose?
No.
So did you actually prepare this report?
I did not prepare the report, no.
Okay, so where did you get your information, Mr. Etheridge, if you're not Mr. Rose?
I did the testing on it, but Melrose filled a report out. He was in training.
Okay. So you were able to say that a gun given to you was matches for some shell casings that were given to you,
Yes,
but you don't know where the gun came from?
do not.
Is there a degree of certainty that you have? What's the margin of error on your results?
Real good at it. No errors.
No errors?
No errors.
100%?
Sure.
Okay. Did you happen to, so how did you say that these match up?
There's a picture of the back of the shell casing where it was fired and made an indention, where the indention was on the 4 that I received were all a match, and then the one that was fired in the lab was a match to the other 4.
Okay, so the gun did fire?
Yes,
Where's the picture of the one that test fire? Where's the picture of the ones that you actually examined?
I don't know.
Okay. Have no other questions, Sherman.
Redirect. Thank you. I think they'd like to get you off the stand as quickly as possible. So,
All that smartness, right?
y'all need a recess for a few minutes, stand up, walk around. All right, let's take about a 10-minute recess and we'll give everybody a chance to walk around a little bit. So.
Pistol sticking out from under the seat.
Okay. Now, to be clear, this white Ford pickup truck, is it the same Ford pickup truck that you observed in the video?
It appears to be that vehicle, yes,
Okay.
sir.
And the defendant who's in the courtroom today was driving,
Yes, sir.
and a pistol that you observed was underneath the...
Yep, underneath the driver's seat, you could see it in the floorboard there.
Okay. And what type of pistol was it?
That was a Glock
A
19.
Glock 19. And you collected it,
Yes, sir.
and it was submitted to the TBI lab for testing?
Yes, sir.
All right. Your Honor, may I approach the witness?
You may.
Detective, can you identify this guy?
Yes, sir. That's a property receipt
And
that was written for Mr. Kyle Bush and the pistol, the Glock 19.
when was it taken out or issued?
October 30th, the same night.
2025?
Yes, sir.
And that identifies the Glock 19?
Yes, sir. The serial number on it.
All right. I'll make that the state's next exhibit, please.
13.
I'll pass the
Exhibit
witness.
13. You may cross-examine.
Detective Morgan,
Yes, ma'am.
how long have you been a detective with the Dixon County Sheriff's?
Since 2013.
All right. So you're really knowledgeable about different things that go on and the policies and things that are distributed to sheriff's deputies.
I would say so, yes.
What kind of guns do y'all carry?
Okay, Glock 19s.
Glock 19?
Well, I carry, if you ask me personally,
Uh-huh.
I carry Glock 19, yes.
Same exact gun that this was?
Yes, ma'am.
And same exact, so it would use the same ammunition?
Caliber?
Yes?
Yes, caliber.
Okay.
I don't know what brand.
How many sheriff's deputies do you think carry Glock 19s?
Think some of our patrol carry them. Not all of our detectives carry them. We're in the transition to changing right now.
All right. And,
So I don't have an exact number on that.
okay. And did you said you just submitted it into evidence? You didn't do any of the testing or anything?
No, ma'am, I collected it when he was taken into custody.
All right. And you picked him up on the warrant, and you said you picked him up on the warrant on 10/30/25?
Same day that's on the sheet, I think so, yes, ma'am.
Okay. Do you happen to know what date the incident happened?
I'm not privy to it, but from what I remember, it was earlier in October, a few
Okay.
days before.
Okay. And while you don't know the exact one, several days had passed between the incident and
Yes, ma'am, a few days had passed, maybe a week.
I have no other questions, Your Honor.
Redirect.
Detective, in your many years' experience with the sheriff's office, I'm not sure that the defense attorney was aware that you are a certified Glock armorer.
Yes, sir.
And being such, you know that each Glock 19 creates independent and unique strike marks, is that correct?
Yes, sir, they do.
So
Each
if
one.
everybody in the sheriff's department carried a Glock 19 and they all fired one round and we collected all these shells,
Yes, sir.
each Glock 19 would create its own unique, independent strike mark based on the ejector pin and firing pin.
The ejector, the extractor, and the firing pin, yes, sir. Each weapon has its own fingerprint,
Each one is unique.
every weapon.
Thank you.
Thank you. You may sit down.
Thank you, sir.
Statement, call your next witness. Well, come around, I'm going to ask you, I remind you rather that you were placed under oath earlier, so you remain under oath.
Ms. Richards, just some follow-up. You were asked some questions, and some of the other witnesses were asked questions about bruising. What's on your arm?
I have a tattoo from here all the way to the end of my arm.
Okay. Did the defendant strike your arm or
Yes.
grab your arm?
Yes.
Were you bruised?
You can't see any bruising if I did have any because of the tattoos.
Okay. You have a tattoo from, I think you indicated your shoulder,
Yes, from the top of my shoulder all the way down to
and
my,
is it complete tattoo?
yes.
No, you can't see skin?
Unless you go to the inside of my arm.
Okay. But where he grabbed you or where he struck you?
Yeah, you cannot see.
So would you know if there was a bruise or not?
No.
All right. Do you know, was there a bruise? But you know he hit you.
Yes.
All right, let's talk about the strike on your face. Did he strike your face?
Yes.
Did it leave a bruise?
Not that I can see, but it just happened the night before.
Okay. What do you mean it just happened the night before? Why is that relevant?
Because the time, I mean, some people bruise, some people don't, but also the time that it takes for a bruise to actually form and the stages of what a bruise can look like. Bruises can turn yellow, which indicates that that's an old bruise, but time is a very important factor. It just happened the night before.
Yeah. He hit your face while you were driving?
Yes.
And obviously, he didn't hit you hard enough to knock you out.
Right. Or for me to lose control of the car. I didn't wreck. I made it home safe.
Yeah. So we know the strike had to have not as much force as it could have.
Right.
Have you ever, in your life, experienced bumping your hand or leg or face or anything on an object and it not bruising?
Yes.
And so that happens. You
Yes.
can be struck or bump into something and no bruise appear.
That's correct.
All right, thank you.
Recross.
You talked about some people's bruising and how some people's bruising looks. How does your bruising look?
If I were to bruise, it would be a little swollen and it would be like purplish.
Okay. And how many days does it take for you to bruise?
I can't answer that. I don't know because I can't remember the exact time that I last had a bruise.
Okay. So you didn't have a bruise during any of this, or you would remember it? It was a couple weeks ago, right?
When I made my report, there was no bruise on my face. Yes.
Well, was there ever one?
No.
Okay. And we saw some pictures of chunks of hair, stuff like that. And you testified earlier that he pulled out chunks of your hair.
He pulled my hair, yes.
Do you have any bald spots?
I wouldn't say bald spots, no.
Okay. I have no other questions, Your Honor.
Jurors have submitted a question, and the question, again, would be considered by me outside the presence of the jury, but the jurors, one of the jurors has asked, if you say you were driving while he pulled your hair, why wasn't the hair in the driver's seat? Either one of you want to ask that question or allow me to?
Richard, you say he pulled your hair while you were driving? And I believe one of the photographs that's been introduced is literally your hair on the driver's seat.
That's correct.
Second time. That's your hair?
Yes,
Driver's seat. That corroborates what you were saying.
yes,
And your hair was in 2 other locations?
yes.
Did you stage this incident?
No,
Did you pull your own hair?
no,
And did you hire a driver to get in a white pickup truck and drive by the sheriff's office and fire 4 shots out the window?
no, sir.
You didn't make this up.
No.
All right, I'll pass the witness.
Recroft?
You're under oath, right?
Yes, ma'am.
And when you took that oath earlier, did they say that if you were to not testify correctly, you could be punished, correct?
That's correct.
So it wouldn't be very beneficial for you to say right now that something you said was incorrect, right?
I didn't say anything that was not correct.
But you would be punished if you had, right?
Absolutely.
So to ask you if you are telling the truth, if you had not been, now wouldn't be a very good time to admit that, right?
It's kind of confusing me. I know that I'm under oath and that everything I've said is the truth.
I have no other questions.
Richard, you voluntarily, willingly took the stand today,
Yes,
knowing you're under oath.
yes.
Is that hard to do,
It is extremely hard.
to tell your story in front of a group of strangers?
Yes.
How does that make you feel?
Vulnerable,
Vulnerable?
terrifying.
And everything you've said today has been the truth.
Yes.
And I appreciate you being here today and being willing to actually testify in front of the jury. Thank you.
Thank you.
Thank you, ma'am. You may sit down and have a seat at the table if you'd like. Mr. Crouch, any other witnesses? State has rested, ladies and gentlemen. At this stage, the next step that would happen in a real trial would be I would ask the jury to step across to the jury room, and then I would consider what's usually called a motion for judgment of acquittal. The defendant has the right to file a motion or make an oral motion for judgment of acquittal to be, it's basically like, there's not enough evidence to convict me and I want you to stop this trial right now. And that's almost every case, every criminal case, the defense will make that motion for a judgment of acquittal at the close of the state's proof. So we hear those motions, and I think in my 11 years on the bench, I have granted one of those judgment of acquittal motions because even the state, I think, agreed that there was not enough evidence. But normally that's denied, and you have to, when a judge considers it, the judge has to consider the evidence in the light most favorable to the state. In other words, take the strongest view of the state's case. So I would deny your motion for judgment of acquittal, Ms. Sylvie. Then step up to the podium and argue that motion if you want to. So.
I would love to, but I don't have a formal indictment, so I'm not 100% sure which counts I'm arguing it against.
Domestic assault. So
That's the only count, one count.
that's all that I know of.
Well, only thing I would say is we have to do an election of offenses because we've had testimony to 2 different dates and we have 1 count.
This is what happens when you get an experienced prosecutor that act as a defense lawyer. They make it more difficult for all of us to do a mock trial. So your motions are all overruled, period. So All right, so the next step would be for the defense to put on any proof that they want to. Does the defendant wish to offer any proof?
Your Honor, my client would like to waive his right to testify.
Then I would, while the jury's out, I would have asked that question. So we'll now ask Mr. Bush to come to this podium, and I will conduct what's called a Momon hearing. That is basically a hearing that I have to ask the defendant questions about his right to testify, and it's based upon a case, I think it was United States versus Momon or something on that order. I'm not actually sure where that comes from, but Mr. Bush, raise your right hand. Let's fake having you placed under oath.
Ma'am.
State your full name for the record.
Kyle Bush.
Mr. Bush, you are here today as a defendant in this case, and I want to make sure that you understand your rights. Do you understand that you have an absolute right to testify at your trial on your own behalf?
Yes, sir.
And if you want to testify, do you understand that no one can prevent you from testifying if you desire to do so?
Yes, sir.
Do you also understand that you have an absolute right not to testify under the Constitution? And if you choose not to testify, no inference of guilt will arise with a jury, and no one can make you testify if you don't want to do so. Do you understand that?
Yes, sir.
Have you talked this over with your lawyer?
Yes, sir.
Have you and she discussed your options and what is in your best interest?
Yes, sir.
Having discussed it with her, what is your decision? Do you wish to testify, or do
No,
you
sir.
waive that right?
I'll waive that right.
All right. Then I would say that you're waiving your right as knowing and voluntary, and we will allow this case to move forward. So,
Yes, sir.
all right. Then I would bring the jury back, and I would, on the record, say, Ms. Sylvie, does the defendant wish to offer any proof?
Your Honor, the defense would rest.
The defendant waived any proof, and so the state would have the right to then make their closing argument to you. State wish to make a closing argument?
Ladies and gentlemen, it's right out of the gate in this case.
Where's our portable microphone?
No doubt. Recovered on the. At block 19 was taken.
He's not going to want to use it anyway.
Together forever. Are unique. Or something?
No, I was going to get them to give you a portable microphone. Certain lawyers are very good at communicating with the jury. One of the ways of doing that is instead of just standing motionless and behind a podium, they want to walk around and engage with us, keep you awake while they're talking. Mr. Crouch is well known for that. He's famous for it, in fact, but he wanders away from the microphone. So we're going to get him a portable microphone for him to hold while he's walking around talking to you.
In the meantime. Only created. Still cases. And then this could not have come from any other money. That evidence is enough to convict domestic assault. It's on. That evidence alone is enough to convict the defendant. because nobody else in the world has this pistol. How did shell casings from his pistol end up at the Dixon County Sheriff's Office but for him firing shots out of his window? You've heard the testimony of the victim who literally saw his truck coming up the road. She ran, you can see her on video, into the Sheriff's Department. You personally can hear the video of the 4 shots that were fired from his pistol. Shell casings were covered. No doubt about that. No matter what questions were asked by Ms. Sylvie, that does not dent the actual proof in this case. Nothing can overcome this proof. Nothing. Anything else is fantasy. He's in possession of the weapon when he's arrested. The alternative to that, if you want to believe what the defense is suggesting, is that our victim just made all this up, pulled hair out, put it in her car, hired a paid actor to drive a truck to the sheriff's department and fire 4 shots out the window. That's ludicrous. How could that even happen? Who would drive to the sheriff's department and fire 4 shots out of a window, except for a man who says this: answer the phone. I know you turned Life 360 on. Think about the rage in the person that sent these text messages. Answer the phone. I know you turned Life 360 on. How would he know that? The air tag. He's tracking her. He's following her. A man that would send this message, that would put an Apple AirTag on your car, registered to his email, is the type of person that would follow you to the sheriff's department and try to kill you as you're going inside. How do we know? You talk, I have something for you. What did he have? Undisputed. But the defense wants to suggest through their questioning that this is made up. That's what text messages look like when a forensic examination is done on a phone. They don't look like how you're reading them on your phone right now. They print out in this version. This is how it printed out after the detective did the forensic examination. It's in black and white. So who cares which side the bubble was on? These are the words sent between the victim and the defendant. He threatened her. He sent a picture of his pistol, which was found in his vehicle, connected to the shell casings. Undisputed. And based on that evidence alone, I'm asking you to convict the defendant of aggravated domestic assault for his attempt to kill her as she went into the sheriff's department. Whether or not you find that she was scared at the bar or not is irrelevant to me, because he tried to murder her. She walked into the sheriff's department. He should be convicted for that offense.
Ms. Sylvie, do you wish to address the jury?
I'm from a different jurisdiction before I'm here now. Where I previously was, we had you cannot get an arm's length from the podium. So I'm probably going to stick a little bit closer to the podium so you can hear me. If the only thing you need is the gun and the ballistics that says this matches this gun, why did we hear and have everything else that was presented today? If that's all you needed, why did we hear everything else? Let's go to a couple different things. We're to believe that someone is absolutely terrified of someone, has keys to their car and a phone, and invites that person or allows that person, whatever word you want to use, get into the car and drive home with them. You have taken this person that you're supposedly so scared of, allowed them to get in your car and drive home with them to a secluded place. That makes no sense. That makes absolutely no sense. The state has the burden of proving here. While he says I make suggestions, the burden is actually on the state. They're the ones that have the burden and the duty to prove beyond a reasonable doubt that what they said happened the way they said for this person to be found guilty. So let's go back to that. So scared, you let him in the car, or allowed him in the car, and instead of staying put in a public place, drove home, had your phone on you the whole time, and never called anybody for any type of help. She also had no bruising. She admitted that she had no bruising. Why wouldn't we have bruising if this happened the way that she said? No bald spots or anything like that for the hair. The hair, that's another thing that was said. While she was there earlier in the day, the hair was collected at night. I asked about whether or not the vehicle was secured during that time frame. The only way that they secured it was they were knowledgeable that it was outside. Was it locked? Was it unlocked? And again, it's her hair in her car. I'm not completely moved by that. Speaking of finding her hair in her car, one of the things, the only thing we really need is the matching of the gun and the bullet, according to the state. But we have a lab report of DNA. The state spent a whole lot of time proving that she was in her car. Wow. You know who they didn't prove was in her car? Mr. Bush. There's no DNA for Mr. Bush being in the car. But a lot of time and effort to prove that her DNA is in her car. The air tag. We have an air tag. No one can tell you when it was placed. No one can tell you who accessed it. No one can tell you what email addresses were used. And we were talking about a text message about Life 360. Well, if you have an air tag, why do you need Life 360? Why would he care that Life 360 was turned off if you've got an air tag tracking someone? Again, all this proves absolutely nothing. The video was up there, and it's no longer up there, but we still have some still pictures. And in that, one of the things that they talk about with this bullet that matches with the gun, the casings were found in a part of the parking lot that the truck was never even in. The truck was never even in that part of the parking lot. And there was 4 casings found, completely different parking lot, where if someone had fired out of the driver's side, we talked about it, would be all the way over on a different side of the road, in the trees and everything. No one found any casings over there. Are we to believe that they went out of the car, over the car, under the car, through into the other parking lot? And the gun that it matches to was found 6 days later. So it matches. Great. Did anybody prove that that was his gun? Yeah, they found it in his car. He was in possession was the word that they used. How did it get there? It had been 6 days. Did anybody prove that he went and bought that gun? There's a picture of the gun. Did you see the gun? Does it match the gun that was in the picture that was sent in the text message? No. State has the burden to prove all of that, and they have not done that for today. I submit to you that Mr. Bush is not guilty.
General Crouch?
He was at the sheriff's office. You can see him. What world are we living in here? This is not being fabricated by the victim. The man drove his white pickup truck to the sheriff's office. One of the things that's so important for you to remember when you start to deliberate, the judge is going to read you some instructions, and in those instructions it says that you may apply your common sense to review this evidence. Think about common sense. All have that. It's common sense that she didn't fabricate this entire story. That's what they're trying to get you to believe. That somebody else was driving his truck. The man can literally be identified in the truck driving to the sheriff's department. Now, you can't see the pistol from the video. It's too far away. But if I'm driving to the left side of the truck going up the hill, I would put the passenger window down, lean, and shoot. Those shell casings are ejected out the window towards the victim. That's how they end up in the parking lot. Again, common sense. You don't have to have a scientist to tell you that. He puts the window up after the shots are fired. Drives up the hill, turns around. His window is down. You can see that in the video. She identified it. This isn't a mystery, ladies and gentlemen. This is on video. An attempted murder is on video with the DNA present. And when I say DNA, I'm referring to shell casings because it's just like DNA. It's unique to him. It's unique to the defendant. Only the pistol found in his possession could have fired those shell casings that were recovered at the sheriff's department. This is all on video. There is no mystery. There is no conspiracy. This is not some weird thing that we're used to seeing on the internet. And that's part of the problem with trials. We all go home and we look on our phones and we read about these conspiracies and these people make up stuff. It sounds like there might be some truth or fiction to it, but if you really use your common sense, you know it's fake. But what's not fake is somebody that is so scared of their boyfriend that they go home after an abusive car ride home and have to lock themselves in their room and wait till he goes to work the next day out of fear. That's why she waited. Because he was drunk, grabbing her, pulling her hair. Broad daylight. Think about what he would have done had she confronted him that night while he was drunk. She might not be here today. This is an absolute case of aggravated domestic assault. The state has definitely proven beyond this. I would ask you to return a swift.
All right, ladies and gentlemen, the next step would be in a real trial for me to hand you your own individual copy of the last instructions I'm going to give you. And you would have been given a copy at the outset of the trial as well when I gave you some initial instructions. But I'm just going to kind of wing it and give you some basic instructions before you retire to deliberate. Ladies and gentlemen of the jury, this will be the final instructions of the court. The defendant, Kyle Bush, is charged in this indictment with a crime of domestic assault, and I'm only using that because there could have, in a real-world situation, the firing of a weapon would have constituted aggravated domestic assault, which is a more serious charge. But we're dealing with domestic assault because I don't think we specified or elected it. So anyway, he is charged with the crime of domestic assault. Necessarily included within those offenses could be some lesser included offenses, which I won't go into. That's more complicated than you need to worry about. The evidence and arguments in this case have been concluded, and it's my duty now to instruct you on the law. The law applicable to this case is stated in these instructions, and it's your duty to carefully consider all of them. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if committed, was committed by the defendant in Dixon County, Tennessee, and it was committed before the finding and returning of the indictment in this case. As heretofore stated, the defendant is charged in the indictment with the crime of domestic assault. Any person who commits a domestic assault upon another is guilty of a crime. For to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to Miss Charlotte Richards, and that the defendant acted intentionally, knowingly, or recklessly. I would then give you a set of instructions that define what bodily injury means under the law, recklessly and knowingly and intentionally mean under the law. If you find the defendant guilty of domestic assault as charged in the indictment, you shall so state. Or if you have a reasonable doubt as to his guilt, then you must find him not guilty of this offense. And if there were other charges, you would then go to those other charges. You'll bear with me for just a minute. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another, to deliberate with a view to reaching an agreement, if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, don't hesitate to re-examine your own views and change your opinion if you're convinced it's erroneous. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render a verdict as absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you'll first select one of your members as a foreman or forelady who will preside over your deliberation. When you have reached a verdict, you will return with it to this courtroom and your foreman or forelady will announce it. There are some other instructions I would give to an actual jury, but that's going to conclude what I'm saying to you tonight. So we'll now allow you to retire to the jury room and decide this case. Around as much. Not really hurting. All right, ladies and gentlemen, I'm told the jury has reached a verdict. So everybody assume your places. Now, ladies and gentlemen, this has been a very emotional trial, and I understand that emotions can run high, and when the jury's verdict is returned, I'm going to caution you all not to show any outbursts, not to have any outbursts of emotion. The jury has done a good job of listening and paying attention, we hope, and as a result of that, I want them to be treated with respect. Bring the jury in, please. And that goes for you, Mr. Defendant, as well. So, did you have a shock vest on him? All right, ladies and gentlemen, everybody be seated. I'm told that the jury has been able to reach a verdict. Is that correct? Then will the foreman or forelady stand and let me go over the verdict with you. As to the count of domestic assault, how did the jury find the defendant? Not guilty or guilty? Not guilty. Is that the unanimous verdict of all 6 of you, 5 of you? Then if you, all right, ladies and gentlemen, the jury having found you not guilty, and General Sylvie having been demoted in her office with the district attorney's office, we thank you for your time. So thank you for your help and time. So now you can go home and go to sleep. So that concludes our mock trial for tonight.
Thank you, guys.
You are welcome. Let me say this to everyone here. I don't know if you've actually sat in on a real trial before, but you had the benefit tonight of having 2 excellent attorneys, both of whom happen to work for the district attorney's office, but they both did a very good job of presenting the proof in the limited time that they had to look over the facts of the case. So you're lucky to have 2 good lawyers who helped us with our trial today. Ladies and gentlemen, we are concluded. Good night.